The part that I'm going to talk about is what we did in East Baton Rouge Parish, which was a jurisdiction that was previously using no counsel present initial appearance court via closed circuit television. And the 8-week pilot project that we engaged in at the end of 2019 in order to not only have counsel present at initial appearance, but to also move our arraignments to follow within a 3-day period of that initial appearance. In Louisiana, we have charging deadlines for the DA to file formal charges in any case. That are very expansive. An individual can be arrested by the police and spend between 45 to 120 days in jail by law before the district attorney is required to file formal charges. And so what we have seen is a massive number of individuals in Louisiana who sit pretrial. They will go in front of a judge for an initial appearance via closed circuit television. And without knowing to ask for a lawyer, they would then get a bond set and not realize they were about to sit for the next 2 months before they were going to be brought to court for arraignment. And so as part of this 8-week pilot project, the district attorney's office agreed to expedite arraignments and file formal charges within 3 days of someone being arrested. The public defender was also present, and the clients were brought to court. If an individual was able to bond out of jail after being arrested, they were given a notice at the jail, and then they would go to court. And so one of the things I wanted to talk about today was the data. What we saw in 8 weeks was a massive improvement on what we had seen in years prior doing no counsel present video initial appearances. We saw that we had over 1,000 people who were a part of this pilot who were processed through those 8 weeks. Even for the individuals who bonded out of jail, we had an impressive appearance rate of 95.7%. And so previously, our failure to appear rate for arraignment was about 50%. And so we saw by moving arraignments up to 3 days later, individuals were far more likely to appear. We also saw, as one of the benefits of moving to those in-person appearances with the public defender present, was an increased amount of collaboration between not just the public defender and potential future clients, but also the ability to communicate with the judge and the district attorney about possible bond adjustments. Because what had previously been happening is an individual would walk in front of a television screen and the judge would look at them without any lawyer there to advocate on their behalf and simply make a bond decision based on the paragraph that the police officer had provided as the probable cause basis for the arrest. And so as a result, you can imagine bonds were relatively high. And so public defenders were able to, with the move to in-person, not only get information that was valuable to adjusting bond decisions, like what's been discussed with some of the presenters in the past, talk about family ties, talk about information that previously wasn't being communicated to the judges about why this individual maybe did not need to be in jail. Maybe this is somebody who was simply too poor to afford the original monetary bond set and so needed to be released. As a result of the expedited arraignment process that we implemented in that pilot project, and as a result of having counsel present, there were 64,000 prison days saved based on what our current pretrial in jail averages are in Louisiana. And so what we saw, though, however, with the implementation of remote court as a result of COVID-19 is that while the judges are still willing to consider bond adjustments, we no longer have that in-person collaboration. We understand that there's a pandemic going on right now, and so that needs to be taken into consideration. But the concern that we are seeing is it does have an immediate impact on the level of monetary bonds that are set in those cases. And so with that 8-week pilot, we know that not only were people being released from jail, we were able to negotiate on cases that much earlier, and we reduced significantly the amount of pretrial detention time that we were seeing in our jurisdiction.